All right, stop whatever you are doing right now, because what I am about to walk you through is not a rumor, not a leak, not anonymous sourcing from someone with an agenda. This is a sworn federal court filing, a 214-page certified transcript. And buried inside it, in a section that every single major outlet completely skipped over, is the most consequential piece of evidence introduced in any case touching this administration. Not the emails, not the wire transfers, something older, something more personal, something that nobody in Trump's inner circle knew existed. Handwritten notes. Written by hand, kept at a private residence, maintained in secret for over 14 months, never entered into any government system, never subpoenaed through any official channel, and turned over to federal prosecutors last month by the one person in that room who was told, explicitly told, before the meeting even started, not to write a single word down. Pam Bondi wrote everything down. And on Thursday morning, she walked into courtroom 14B and handed all of it to prosecutors, along with 47 emails, along with wire transfer confirmations totaling $18.2 million, along with a guided tour of a $127 million financial architecture that 3 shell companies were built to move, hide, and dissolve before anyone could trace it. I have been inside this transcript since Wednesday night. 4 hours of reading, 2 complete passes. Every exhibit, every appendix entry, every footnote that nobody else bothered to read. And what I found in the pages that the headlines never touched is what this entire breakdown is about. If you want this level of document breakdown the moment federal filings drop, subscribe right now and hit the bell. I read every page, so you do not have to spend 18 hours doing what I just did. This story is moving faster than any standard news cycle can keep pace with. Subscribe now. Let us get into it. Start with what these handwritten notes actually are, because this is where most coverage stops at the surface and where the real story begins. Page 147, appendix section. Easy to miss if you're reading quickly. Impossible to miss if you stop and actually read it. Bondi testified about a specific meeting. Mar-a-Lago, February 2025, 8 people in the room. A meeting that does not appear anywhere in any White House scheduling system. No official record, no staff documentation, no calendar entry, no security log that has been made public. By every formal measure, this meeting did not happen. Except it did, and Bondi was there. Her testimony includes this exact language, and I am reading directly from the transcript. I was instructed not to document the conversation. I was told this explicitly by 2 people in that room before the meeting began. Before the meeting even started, 2 people, separately, told her directly, do not write this down. Do not document this. This conversation does not leave this room. She went home that night and wrote down everything she remembered. Sit with that for a moment. She was in a room with some of the most powerful people in the country. She was told by 2 of them, before a single word of the actual meeting had been spoken, that nothing from this conversation should exist in any record. And she left that room, drove, or was driven back to wherever she was staying, and she wrote down every detail she could recall. Not on a government device. Not in any system that could be tracked or audited or subpoenaed through standard channels. On personal paper. In her own handwriting. Kept at her private residence for the next 14 months. Those notes were turned over to federal prosecutors last month, before her immunity agreement was even finalized. She did not hand them over as part of a transaction, as a bargaining chip negotiated across a table. She had been holding them, maintaining them, keeping them secure. And she brought them to prosecutors as a demonstration of the value of what she was offering before anyone had given her anything in return. What is in those notes is the question that changes everything else about this case. The notes describe a $340 million development project. Qatar on one side, American business partners on the domestic side, a foreign sovereign wealth fund providing the financing. And then there is the instruction that was delivered in that room at Mar-a-Lago in February of 2025, at a meeting that was never supposed to leave a record of any kind. The instruction, as documented in Bondi's handwriting and now in federal hands, was to structure the transaction specifically to keep it beneath the threshold that would trigger mandatory review by CFUS. CFIUS is the Committee on Foreign Investment in the United States. Its entire purpose, the reason it was created, the reason it exists as a federal body with statutory authority, is to evaluate transactions involving foreign capital that could affect American national security. A $340 million deal involving a foreign sovereign wealth fund is precisely the kind of transaction that CFIUS was designed to examine. The explicit instruction, given in a room where everyone present had been told not to document anything, was to keep this deal away from them. BONDI'S notes contain 5 words that prosecutors have now placed at the absolute center of their intent argument. 5 words that appear in her handwriting on paper she maintained in secret for over a year. They know the threshold. Stay under. Not structure appropriately. Not ensure compliance. Not minimize regulatory friction. Stay under. Under the number. Under the threshold. Under the radar of the federal body whose jurisdiction this deal would otherwise fall directly within. 5 words. In BONDI'S handwriting, from a meeting that was explicitly designed to produce no documentation of any kind, now in federal hands. Let me explain why those 5 words matter more than almost anything else in this 214-page transcript. Intent is what separates a complex financial structure from a criminal case. Prosecutors can build elaborate pictures of layered transactions, shell companies, jurisdictions chosen for minimal disclosure requirements, payments routed through entities that existed for 17 days and then dissolved. They can lay all of that out in meticulous detail. But without intent, without evidence that the people who built those structures knew what they were doing and chose to do it specifically to evade legal oversight, they have architecture. They do not have a crime. Intent almost never exists in writing. It lives in conversations, in verbal instructions, in the shared understanding between people who are running a system together and who know exactly why that system was built the way it was. Proving intent in a financial case of this complexity is the hardest part. It is almost always the part that requires the most work, the most circumstantial inference, the most painstaking assembly of indirect evidence. Bondi walked into courtroom 14B with direct evidence of intent in her own handwriting from the room where the instructions were given, at a meeting that was specifically designed to leave no record of those instructions. They know the threshold. Stay under. That is not circumstantial. That is not inferential. That is a contemporaneous written record of the stated goal of the people who designed the transaction structure prosecutors have spent months documenting through independent channels. Now, let me back up and explain who Pam Bondi actually was inside this administration, because it is impossible to understand why Thursday is different from every previous legal development in Trump's orbit without understanding what she represented and what her presence in courtroom 14B actually means. Bondi was not a peripheral figure. She was not a contractor brought in for a limited task. She was not an outside advisor with partial visibility into how the operation actually functioned. She was the Attorney General of the United States, nominated by Trump in late 2024, confirmed in early 2025. And from that moment forward, she was the institutional shield between federal prosecutors and everyone she served. Every subpoena that came too close, she was there. Every investigation that started developing real momentum, she was positioned to manage it. Every thread that SDNY started pulling that led somewhere uncomfortable, Bondi was at the point where those threats could be slowed, redirected, neutralized. She used the full weight of the Justice Department she led to push back against exactly the kind of inquiry that she is now feeding from the inside. She was trusted with everything because her entire role required that trust. She sat in classified briefings. She was present for the sensitive meetings. She was in the rooms where the actual decisions were made, not because she stumbled into them, because her presence there was essential to how the operation ran. She was also, it now appears, watching all of it, taking notes, saving emails, building a record that nobody around her knew she was building for over a year, while standing in front of cameras and calling every investigation politically motivated overreach, while using the platform of the nation's top law enforcement officer to dismiss the very inquiries she was quietly, methodically preparing to assist. The timeline of how we arrived at Thursday stripped down to what actually matters. Weeks ago, federal investigators issued subpoenas targeting 3 holding companies registered in Delaware. These were not fishing expeditions. By the time those subpoenas landed, prosecutors already had banking records, internal communications, and corporate filing histories that told a partial story. What they needed was someone who could fill in the intentionality. Someone who could explain not just what the structures were, but why they were built the way they were, who designed them, and who gave the instructions that shaped every decision within them. Shortly after the subpoenas landed, Bondi's personal attorney made 2 separate trips to meet with the prosecution team. 2 meetings, not one. The first meeting is exploratory. What do you have? What do you need? What might be possible? The second meeting means the first one went well enough to continue. By the time the second meeting concluded, the basic framework of an immunity agreement was already taking shape. Monday of this week, the agreement was formalized and signed. Wednesday, BONDI'S legal team submitted the documentary evidence she was bringing to Thursday's proceeding. Court records indicate that prosecutors spent Wednesday night reviewing what she had provided. The emergency status updates filed late Wednesday night, before a single word of her testimony had been delivered, tell you everything you need to know about the quality of what she brought. Thursday morning, Courtroom 14B, Pam Bondi, former Attorney General of the United States, took the stand as a cooperating federal witness with full immunity and apparently very few regrets about being there. Now let us go through what the documents actually say, because this is where every headline stopped at the surface and where the actual story lives. First document filed Friday morning, page 34. The language here is careful and specific in a way that matters legally. The filing states that the witness confirmed direct knowledge of 3 separate agreements executed between January 2025 and August 2025, each involving payments routed through intermediary entities. Every word in that sentence is doing work. Direct knowledge means she was not informed about these agreements secondhand. She was not reading a report prepared by someone else. She was present. She reviewed the documentation personally. She can testify to what she observed with firsthand authority. 3 separate agreements means this was not a single anomalous transaction. This was a pattern, executed across multiple distinct instances over an 8-month period. Payments routed through intermediary entities means the money did not travel directly between its origin and its destination. It moved through structures whose purpose was to complicate the audit trail. Bondi watched all of it. She knows where every dollar started and where every dollar landed. Page 89, paragraph 47. This is where the first real alarm registers. Bondi testified under oath that she personally reviewed wire transfer confirmations totaling $18.2 million. All of it directed to a single Nevada holding company. A company that, per Bondi's testimony and subsequently confirmed through the Nevada Corporate Registry, had no employees at any point during its existence. No physical office, no website, no phone listing. No identifiable business activity of any description. I checked the Nevada records independently after reading this. The company was registered 6 days before the first wire transfer arrived. It was formally dissolved 11 days after the final payment cleared. 6 days before, 11 days after. 17 days of total corporate existence. $18.2 million moved through it during that window. Then gone. This was not a poorly structured, legitimate business. This was a purpose-built instrument, created for a specific function, used precisely, then eliminated. The people who designed it knew exactly what they were doing. The precision is what separates this from carelessness. Careless people do not register a company 6 days before a payment arrives. Careless people do not dissolve a company 11 days after the last payment clears. This level of timing requires advanced knowledge, deliberate planning, and a clear intention to make the structure as difficult to trace as possible after its usefulness has expired. Page 52. This one received almost no coverage anywhere, and I want to spend real time here because it matters more than its brief mention in initial reports suggests. Bondi testified that she was present at a meeting in which the selection criteria for the intermediary entities was explicitly discussed, not the existence of the entities. The criteria used to choose them. Delaware for minimal disclosure requirements. Nevada for the absence of beneficial ownership reporting. Cyprus for the banking relationship flexibility that jurisdiction provides. These were not chosen at random. They were not chosen by accountants trying to reduce a client's tax burden through standard international business practice. They were chosen by people who understood exactly what each jurisdiction would and would not require in terms of documentation, and who made their selections based on that understanding. The structure was designed around what it needed to avoid, not around what it needed to accomplish. Page 112, Exhibit F. I went through this section 3 times because the implications take a moment to fully land. Bondi provided prosecutors with 47 emails. 47. All correspondence between herself and 3 named members of Trump's inner circle. All sent during a 14-day period last spring. all originating from an account she maintained while serving as Attorney General of the United States. The subject lines, and I am reading directly from what is quoted in the transcript, included the phrases repayment arrangement and offshore structure urgent. The chief law enforcement officer of the United States was receiving emails marked urgent about offshore structures and repayment arrangements while sitting in the Attorney General's office, and she did not delete them. She saved every single one. And she handed all 47 to federal prosecutors along with testimony explaining exactly what each one meant and what decisions followed from each exchange. Why did she save them? Why did she keep the emails and the notes and the wire transfer confirmations when the easier, safer, cleaner thing would have been to delete them, to let them disappear, to maintain the loyalty that was expected of her and that she publicly performed for over a year? Maybe it was instinct. Maybe it was the calculation of an experienced attorney who understood from the very beginning that a day like Thursday might come and that when it came, the only protection available would be documentation. Maybe she watched what happened to Michael Cohen. She watched what happened to Rudy Giuliani. She watched what happened to every person in this orbit who stayed loyal past the point where loyalty could protect them from their own legal exposure. And she made a different calculation, earlier than most, quietly, methodically, while standing in front of cameras and saying the opposite of everything she was preparing to deliver. Page 134. This is where the transcript shifts from financial architecture to something more direct. Bondi testified about a conversation in which she was explicitly told that certain communication should move off standard channels. The language she quoted is precise. Use the other platform for anything involving the arrangement. The other platform. Prosecutors already have records of which platform obtained through a separate subpoena process. Those records are referenced in the filing as Exhibit J, which as of this writing remains under seal pending review. What is in Exhibit J will become clear when the seal lifts. The speed with which prosecutors moved after Thursday suggests they already know exactly what it contains. Thursday, 2:47 p.m. Eastern. This is the timestamp that matters. This is the moment that sent 3 reporters running from the courtroom simultaneously. This is the moment that will be referenced in every subsequent filing in this case. Bondi was under direct examination. The questioning had been moving through the financial structures methodically for nearly 2 hours. Then the prosecutor shifted to a specific date, Oval Office, February 14th, 2025, Valentine's Day. Bondi paused. She looked at her attorney. Her attorney gave no visible response. She turned back to the prosecutor and she answered. I was present when the president discussed structuring the Doha Agreement to avoid congressional notification requirements. The courtroom went quiet in a way that people present described afterward as physically distinct from ordinary silence. Not the quiet of a lull in proceedings. The quiet of a room full of people absorbing something they understood immediately was irreversible. Trump's defense attorney called an immediate sidebar. The judge granted it. Prosecutors requested a 15-minute recess. 3 reporters left simultaneously to file breaking alerts. When testimony resumed 23 minutes later, Bondi walked through the February 14th meeting with the systematic precision of someone who has replayed it many times and knows exactly which details carry weight. The Doha Agreement, $340 million. Qatar. American business partners. Foreign Sovereign Wealth Fund. And the explicit instruction to structure the transaction below the thresholds that would require congressional notification and CFIUS review. Delivered in the Oval Office, with 8 people present, by the person sitting behind the Resolute desk. While every outlet focused on the dollar figure in their initial breaking news coverage, something else was happening in that courtroom that received almost no attention in the hours immediately following. Bondi named 8 people, not Trump alone. 8 individuals who were present at the February 14th meeting or directly involved in the broader arrangements she was describing. Current officials, former officials, and 1 sitting member of Congress. The transcript was partially sealed within an hour of that testimony concluding, but not before the reporters who remained in the courtroom had the essential framework of what had been said. Friday morning, one of the 8 individuals named by Bondi publicly announced the retention of a white-collar criminal defense firm in Washington and released a statement through that firm denying any wrongdoing. No journalist had published his name. No outlet had connected him to the testimony. He issued a denial before anyone had asked him for a response. That is not the behavior of someone with nothing to worry about. That is the behavior of someone who knows their name is in a sealed court document and is trying to establish a public record of denial before the seal lifts. The congressman's office issued no comment and redirected every media inquiry to legal counsel. A member of Congress with no connection to any of this would say so. A member of Congress who needs to manage every word carefully while consulting with lawyers about their own exposure would say nothing and let attorneys speak. The judge responded by scheduling an emergency status conference for Tuesday and granting prosecutors expedited discovery within hours of receiving the request. Something in that testimony, possibly in the sealed portion, possibly in the specific names and specific dollar amounts that were placed on the record, accelerated everyone's timeline simultaneously. The immediate fallout from Thursday began before Bondi had even left the building. 3 additional subpoenas were issued Friday afternoon. 2 former White House staffers, 1 current member of Trump's personal legal team whose communications with Bondi appear in the 47 emails she provided. The Nevada LLC is now under active federal investigation separate from the broader case. Prosecutors filed requests for banking records from 4 international financial institutions on an emergency basis with a 72-hour compliance window. One of those institutions operates in the Cayman Islands, one in Cyprus. Both jurisdictions appeared in Bondi's testimony as locations where elements of the payment structure were routed. The request was filed on an emergency basis and granted the same day. Think about that timeline. Bondi finishes testifying Thursday afternoon. By Saturday morning, prosecutors had already moved on 4 separate fronts simultaneously. That is not the pace of an investigation feeling its way forward. That is the pace of an investigation that has been waiting for one final piece to fall into place and is now moving on everything at once because that piece has arrived. Bondi was that piece, not because her testimony alone proves everything, because her testimony explained and contextualized everything prosecutors already had, but could not fully connect without someone who had been inside the room where the decisions were made. Now, the other side of this deserves a genuine hearing, and I want to give it one. Trump's legal team has made arguments this week that are not all easily dismissed, and intellectual honesty requires engaging with them seriously rather than waving them aside. The first and most substantive argument is about incentive structure. Bondi has immunity. That is not a neutral status. Immunity means she faced legal exposure of her own, and she negotiated her way out of it by agreeing to cooperate. That creates a dynamic where everything she says in that courtroom serves her own legal interests. Cooperation agreements in federal cases create real pressure to deliver testimony that satisfies the people who granted the deal. That pressure does not automatically produce false testimony, but it does mean that this witness has a powerful personal stake in the usefulness of what she provides. Every honest analysis of this case has to hold that fact consistently in view. Trump's lead attorney put it directly Thursday night. She faced serious criminal exposure and purchased her freedom by constructing a narrative that prosecutors needed to hear. I do not accept that characterization as complete, but the structural logic underlying it is real. Prosecutors do not grant immunity to people who have nothing to offer. Bondi had to bring something worth the price of the deal she received. Pressure to deliver creates some pressure to embellish. That is a dynamic worth acknowledging. Second argument. The financial structures themselves are legal instruments. Delaware LLCs, Nevada holding companies, Cayman Islands banking relationships, layered payment routing. These are mechanisms used by thousands of legitimate businesses every day. Structural complexity is not criminality. Offshore does not automatically mean fraud. Choosing a jurisdiction for its favorable disclosure requirements is standard international business practice. A former federal judge now teaching at Georgetown Law said on Friday that the sophistication of a transaction structure does not establish the intent behind it. You need more than architecture to prove criminal purpose. Third argument. The timing of Bondi's documentation raises real questions. She held these notes for 14 months. She held the emails. She maintained all of it while publicly defending the administration and calling every investigation politically motivated. If she genuinely believed serious wrongdoing was occurring, the argument goes, why did she wait until she herself was facing legal jeopardy before bringing any of it forward? These are real arguments. I am not dismissing them. What separates this from a situation where they might be decisive is the nature of the documentation itself. Bondi did not come to prosecutors with her memory and her interpretation. She came with physical evidence, wire transfer confirmations that exist independently of her account of them, emails that exist on servers and can be verified against the originals, handwritten notes dated contemporaneously with the events they describe, turned over before any immunity deal was signed. You can attack a witness's credibility. You can introduce evidence of her incentives, her timing, her self-interest. But you cannot attack a timestamp on a wire transfer. You cannot cross-examine an email header. You cannot impeach a corporate dissolution date in the Nevada State Registry. The documentation is independently verifiable. And that is what makes this case different from every previous situation where someone in this orbit has claimed to have information, but arrived with only their word to support it. What the people who actually work in this area of law are saying is worth laying out, because the consensus across people who disagree about nearly everything else in this case is striking in its consistency. A former assistant U.S. attorney with 17 years at SDNY described BONDI'S testimony as a structural inflection point rather than an incremental development. When a cabinet-level official provides contemporaneous documentation as part of a cooperation agreement, you are no longer dealing primarily with a witness credibility question. You are dealing with a documentary evidence case that uses the witness to explain and contextualize what the documents already show. Those are fundamentally different evidentiary situations. And prosecutors in documentary evidence situations move very differently. A criminal defense attorney with 22 years of federal practice said something that I keep returning to. The immunity deal is the most reliable signal available to outside observers about the strength of what prosecutors received. Federal prosecutors do not grant full immunity agreements for marginal value. The cost of immunity is the potential prosecution that gets surrendered. Prosecutors only pay that cost when what they receive in return substantially exceeds what they give up. Bondi brought something that outweighed her own criminal exposure, by definition. That is not my characterization of her testimony. That is the structural logic of how immunity agreements function in federal law. A former White House counsel who served in a previous administration told CNN Friday that the documentation is the problem the defense cannot solve through standard witness attacks. Cross-examination affects testimony. It does not affect wire transfer records, email server logs, or handwritten notes dated months before any cooperation agreement was contemplated. When the documentary evidence is independently verifiable, the entire defense strategy has to work around it rather than through it. And working around documents this specific, this voluminous, and this independently corroborated is an extraordinarily difficult legal task. A constitutional law professor at NYU described Thursday in terms that extend beyond the specific proceedings. The question being examined in real time is not merely whether these specific individuals committed these specific acts. The question is whether the accountability structures built into American law function as designed when the individuals subject to those structures held the positions that were specifically created to manage them. The sealed portion of the transcript is the central unknown right now, and it is worth spending time here. Bondi testified for 4 hours. 90 minutes are in the public record. 150 minutes are under seal at the prosecution's request. That proportion, more than half of her total testimony protected, is not routine. Prosecutors seal testimony for specific reasons. They are protecting the identity of individuals who have not yet been charged and whose premature public identification would allow them to coordinate responses or destroy evidence. They are protecting evidentiary chains that depend on maintaining the element of surprise for upcoming steps. They are protecting cooperating witnesses other than Bondi whose existence and cooperation have not yet been disclosed. Any of those three explanations suggests the sealed portion is more operationally significant than the public portion, not less. The most explosive material in a major federal case is almost never the part that becomes immediately public. Tuesday's status conference is where this moves next. The privilege dispute. Trump's attorneys filed a motion Saturday morning to exclude certain portions of Bondi's testimony on attorney-client privilege grounds. Prosecutors responded the same day. Bondi was not functioning as Trump's legal counsel during the conversations in question. She was a cabinet official present at meetings, a witness to events, not an attorney providing protected advice to a client. Attorney-client privilege has specific requirements, and the circumstances Bondi described do not map onto those requirements. The legal consensus is that the motion will fail. If it fails, more of the sealed testimony enters the public record, and the acceleration that began Friday continues. If it somehow succeeds through an unexpected ruling, it buys time. But it does not make the underlying documentation disappear. The emails, the wire transfers, the handwritten notes from the meeting that was never supposed to produce any documentation at all. Those exist regardless of what happens to the verbal testimony surrounding them. Trump's response to Thursday has followed the established pattern and has been